Welcome to Authentic Ingenuity Entrepreneur. My name is Minna, and today I will be walking you through the next episode is in regards to the continuing from the last episode with the case against my employer, the Ministry of Justice. On the 25th of August 2023, my application is now ready to be submitted to the parties, to the courts, and to council. So with that, this is like me working day and night, hardly sleeping, literally working day and night on these applications, trying to meet the time frame that the judge had set for us. I go to the High Courts to submit my application, but because it was an interlocutory application to enter a summary judgment of liability, I needed the courts or a deputy registrar to actually sign the documents. Because I wanted it sworn, I wanted the exhibit sworn, I had everything all ready. Unfortunately, when I got to the courts at this day, on this particular day, and just like everything else, they knew I was coming. The registrar refused to sign my interlocutory application and treated me like I didn't know what I was talking about, and asked me to explain what my application was about. And I said to him, well, I had a deadline to meet today. The judge made a direction in his minute that I had to make my submission today on the 25th of August 2023. She basically asked me questions like in regards to explain to her what the application is for. I just said, well, it means that they've got no evidence and I'm asking the judge to make a judgment of liability. And along with that, had exhibits and other affidavits in submission for that application. Said that I had to change my document, and I said no, I don't want to change my document. This is the document I want to submit to the courts. And they said, well, they're not going to sign it unless I change the heading of the document. They didn't want me to swear my documents, even though that is what I wanted done. Instead, they said that I had to, that the proper process was I had to put in a notice of opposition. And I says, no, this is the correct procedure according to the laws, because the defendants don't have a case. It's a criminal case. It's a miscarriage of justice. I said things like that. I said a lot of things along those lines, trying to convince them, but I could tell quite clearly that they weren't going to make it easy for me. Well, I actually asked to speak to her manager. Her manager came on the scene, supported her, and I says, look, the judge has already given a direction and these documents are due in today and they need to be submitted today for the courts and the councils. However, they still refused to take my documents, and with that, the deputy registrar threatened to get the security to take me off the premises if I didn't do what they told me to do. So keeping in mind the registrar is telling me what to put on my documents, and I'm saying no, you can't do that, you're not allowed to do that, and that is not what I'm submitting. But and knowing the background, I already knew that I'd already let the registrars or the case officer know and the judge know in writing. I've already gone through this process, but this person that was serving me didn't know the background of the case, and she was demanding me to change the documents on my document, and I refused. And so with that, because I refused, she rang the security to come and escort me off the property. I remained calm, but in my heart, I was like petrified with what they were doing. I was horrified. I was traumatized with what they were doing, but I remained calm. And I said and then the securities came and they was like, you need to listen, you need to do or something along those lines. And I said, no. I said, the judge has already made a direction, and these applications need to go before the judge today, or before the courts and councils, so I can let councils know I've submitted them, because I can't serve them until I've served it to the court first. That's how it works. And then with that, and I said to the security, you guys don't need to do that. I'm not the criminal. I'm actually the victim. But I remained calm. I was like shaking. But I just remained calm and just, try not to overreact. But with that, I rang 111. Now, this is the second time I have rung the police to do with this case, where the courts have refused or perverted the course of justice. So it's quite clear I'm blocked out, blacklisted. So this is the kind of case that I'm going through on my own. So what happened with that, I rang 111 because I wasn't going to leave the premises until, somebody came and took my documents, because they were due that day. And then with that, I rang 111. Something must have happened, because a lady from her name was Katrina. She came down. I assume she's probably someone senior, probably from the judge's chambers, asked what was the problem. She questioned the document and said that, where's your notice of objection? And I said to her, it's there. And she had a look at it. She said, where? I can't see it. And it was quite obvious she was looking for the word objection. And I said, it's there. I had to grab an example, and it's all there in the laws, because that's how it is when you are a lawyer. You submit things using the law, and the laws interpret, and as the authority of that law is what that it clearly articulates and states what that document is for. Anyway, with that, she decided to take all the documents that I had brought to court, and then I just left the courts, and then I just went home. A side note, I was absolutely traumatized and horrified with what they did to me, but I knew I had to, because the deputy registrar said that I had to review her decision if I didn't like her decision. But because it's already a court matter and the judge has already made direction, I put it in a memorandum, because I had to notify the councils why, because now to them they think I didn't meet the deadline. But yeah, so that's what happened. And so with that, I put a memorandum and addressed it to the judge, the same judge who wrote the minute, Associate Judge Brighton. He wrote the minute on the 26th of July 2023. So that memorandum went straight to judge. And with that, the judge set a teleconference for the same week on Wednesday, which was the 30th. So the memo was submitted first thing on Monday, the 28th of August, and the judge did a minute on the 30th of August 2023 for a teleconference. So with that, I also asked, put in another minute because I'd wanted the teleconference room at the High Court to be booked out because I wanted to go to the court and have the teleconference there rather than having it from my home. On Wednesday, the 30th of August 2023, I go to the High Court and I go to a room as directed by the courts where to go, and I booked out a room for a teleconference set up, and then the teleconference took place, and it was we all did it on the phone. I had my mobile, and I did notice that there was a caller from Australia had logged in. I don't know who it was. I assume it might have been the judge. So the people that were actually in the teleconference on this particular day was Crown, was for Katie Craig, and then myself, and then the case officer, and then the judge. Okay, so the judge opened the court, opened the hearing, and he opened it. Obviously, there he was talking about what happened with my submission on Friday and the documents that I was trying to submit. And then Katie, the Crown, spoke, and I just sat back and listened, and as they were talking, and I did gather during the conversation that there was a bit of a confusion with the documents that I had actually officially lodged over the counter. So the Crown made their submission. Sounded a little bit confusing with them, and then it was my turn. The judge let me talk, and then I made it clear to him that the actual document that I was submitting and that I wanted the courts to sign and they refused to sign it was an interlocutory application to enter a summary judgment of liability. I said to the judge that the case is actually a miscarriage of justice, and it's a case of anticipated breaches. So I do recall saying that at the hearing. Obviously, we didn't have very much time, and then judge, I wasn't sure whether even judge had the files in front of him, or I don't know. We know that there was definitely a confusion with the Crown, but there was no confusion on my part because I knew that I had actually forwarded these applications to the Crown and to the courts. Now, on that note, I have had, like, what I'm going through is so personal and so intimate that in between, I have had problems where somebody is deleting my emails between my correspondence with the courts, whether it's somebody that's surveillancing me in my home or somebody in the courts in between. So if I say I've done something, I normally never get it wrong because I'm that sufficient. But I thought I'd mention that because that's how personal this case, or what's been happening to me, has been that personal and that intimate. Because this has been going on for so long, you know, people using me and then deleting evidence like nothing happened. And then when I go to say something, everyone thinks I'm crazy because the evidence is gone or people are treating me invisible. So when it was my turn to talk, I made it clear to the judge that I had already submitted the documents to the Crown and to the courts, and that the actual title of the documentation that I needed to swear was the interlocutory application to enter a summary judgment of liability. With that, the judge said that he didn't think I could do that, and I sort of said, I addressed to him quickly of the laws that allows me to apply for that application. He says, he granted leave. He said I can use it. However, I wanted the application to be sworn. So, but that didn't happen. The judge said he would allow and grant leave for me to actually use my application in court, because the Crown were trying to make the Crown was stating that I was going down the wrong avenue as far as the application was concerned. I knew I wasn't, and so that was the teleconference on this particular day. With that, the judge granted leave for me to use that application, and then I had to actually respond to the council's notice of opposition, because I was unfamiliar with the scheduling, because this is all the new age system. But according to the law, it's nothing to do with me being old school. It's actually to do with the law and knowing my case, that the defendants had no case. So basically I wanted a judgment of liability because I was confident I was able to prove all that in documentations, and if required, a proper investigation in the summons everyone into court if there's some kind of confusion or anything like that. That's how it usually works. But I was adamant that the defendants had no case to answer, and when it is a miscarriage of justice, it is automatically a criminal case, 100%, and because it was my employer too. The judge granted leave for the application to be heard. I could use it instead of me retyping it and changing everything, because I had put like nearly 4 or 5 months in this application, and keeping in mind I had another hearing leading up to this, and that was the hold up. But the courts were aware of it. There was another case officer who was before this new case officer who confirmed, and another deputy registrar actually confirmed, that my next step was a judgment of liability. Okay, now a judgment of liability, there is no fee, and that was what I told the courts, that there is no fee for a judgment liability. And then they would say, well, where does it say that? I felt like they were just using me for information, but that's how I felt, and it was just very degrading. Also, if you are in hardship on the benefit and you can't afford to pay for the court fees and stuff like that, they do have waiver fees form, and that is for the purposes of people who can't afford the court fees. And you don't have to be a New Zealand citizen to qualify for it either, because that's what's happened, I believe, with my application. It's just been a black and white, a discrimination. But I did use the waiver fees for all my applications when I couldn't, keeping in mind I lost my job because of what my employer and everyone else did. So it's not because I'm not working because I don't want to work or I can't get a job. but what my employer did to me ruined my reputation, and everything that happened was intentional, so I could never go back to work or recover financially. He gave the instructions to allow my documents. He granted leave. He said he granted leave for my documents that I had submitted on the 25th of August 2023 to be used at the first case management conference, which was the 1st of November. So judge actually allowed that. I could tell during the conference that the opposition was trying to not allow my documents to be sworn, because I wanted it to be sworn, but they refused to swear it. But the judge allowed that document to still be used. So I didn't get my exhibits affidavit sworn, and I didn't get my interlocutory sworn, but the judge allowed those documents to be used at the first case management conference. However, he did allow me to have my affidavit of service sworn in support of the interlocutory application. There was 2 separate applications for that. Affidavit of myself and another witness in support of to enter a judgment of liability dated the 25th of August 2023.